Kenneth Chesebro moves for a speedy trial in Atlanta. First, he turns himself in, he surrenders and gets arrested. He's the sixth person to turn himself in the 19-count RICO indictment in Fulton County in Atlanta, being prosecuted by a state prosecutor, Fani there. And he was released on $50,000 bond. That's a consent bond that he, his lawyer, and the prosecutor and the judge all agreed was a fair amount that he had to post. He only has to post a fraction of it, I think 10%, in order to be released. But Kenneth Chesebro, who is he? And how did he find himself in this mess? And what is he doing now that he's moving for a speedy trial? Let's talk about this. Ken Chesebro was a nerdy Harvard lawyer, apparently, but he's also co-conspirator number 5 in Jack Smith's January 6th indictment. He used to be liberal, according to people who knew him back then at Harvard, and they called him Cheese, obviously for his name, but as well as because he's from Wisconsin, and that was his nickname. But he apparently made boatloads of money in Bitcoin, and he made a hard right to the MAGA extremists, and that's where he is. And he was a lawyer, really smart lawyer, well, he still is, apparently, who had a reputation for being nerdy and smart, but he really bends the law in bizarre ways. And we know this based on the memos that we have seen that he wrote for Donald Trump, candidate Trump, who wanted to upend the results of the 2020 election. And he wrote these memos that there are at least 2, if not more, where he spelled out this entire fake elector scheme, right? He said that all you need to do is get these fake slates of electors in the 7 battleground states and just cast some doubt into who the winner is and get Mike Pence to push it back down to the states because there's doubt, because he wants them to claim that Pence didn't know who won, even though he did know who won, and then push it back down to the states that by and large have Republican legislatures, who then they could decide which electors to put in place and literally steal the vote from the American people who cast lawful votes. So that's who Ken Chesebro is. He's the architect of that scheme. So as I said, he appears in the January 6th indictment as co-conspirator number 5. He's mentioned at least a dozen times, maybe more. And in there, it's clear that he's the one who's the mastermind that devised this fake elector plot. He was charged in Fani Willis's case under RICO, the Racketeering Influence Corrupt Organizations statute. And there he's charged with being the architect of causing the 6 Georgia Republican electors, fake electors, to sign the fake certificate. He was the brains behind the scheme. And so he has now been charged. He's also, we recently learned, he was on the ground on January 6th, following around Alex Jones, the conspiracy theorist, right? The guy who claimed that, Sandy Hook was a hoax, and he's, just this massive InfoWars conspiracy theorist. So Ken Chesebro, he wanted to hold himself out as a lawyer giving legal advice. And Donald Trump wanted to hide behind that, saying, I'm not guilty. I was relying on my lawyer. But he really was more of an activist trying to help steal the election and was on the ground at the time on January 6th, making sure that it happened because chaos and havoc was part of his plan to try to put pressure on the Supreme Court to allow this scheme to occur. So let's talk about what's happening in Georgia. He is the only of the 19 defendants so far who has said, I want a speedy trial. Okay, and what does that mean in Georgia? Now, all states and the federal government, they all have some kind of speedy trial requirement, right? In New York, for example, for a felony, you have 6 months from the time that you file an accusatory instrument to the time that you are ready for trial. You have 6 months to answer ready, or the case gets dismissed. And obviously cases take longer because sometimes are excludable, right? Motion practice, etc. Well, Georgia has a very unique speedy trial statute that is lightning speed. And many people have surmised that Fani Willis obviously knows about this statute, which is because she practices exclusively in Georgia state court. And therefore, that's why she took so long to bring this case. There were lots of people who were criticizing her, excuse me, for taking 2.5 years to bring this case. But apparently the reason she took so long was she knew if any of these 19 defendants requested a speedy trial, then she had to be ready. And so she was not going to file the case until she was 100% ready to go to trial the very next day if she had to. And the way it works in Georgia is the speedy trial law. It's a very, very short time period. It's found in Georgia law. It's OCGA section 17-7-1780 sub A. And I'm just going to read the relevant part that Ken Chesebro cited in his 2-page or 1.5-page motion for speedy trial. It says any defendant against who a true bill of indictment, that just means an indictment, is filed with the clerk for an offense not affecting the defendant's life, meaning it's not a death penalty case, may enter a demand for speedy trial at the court term at which the indictment is filed or at the next succeeding regular court term thereafter. So if this indictment was just filed in August, they have to either be ready during this court term, right? That goes from, they have different court terms, right? So this one goes to the end of August, but then there's another one that goes from July, September, and November, right? So you've got these different court terms. So she's really going to have to be ready by the end of November. So before the end of the year.
This is Michael Popak, Legal AF. Cold turkey may be great on sandwiches, but there's a better way to break your bad habits. We're not talking about some weird mind voodoo from your wacky neighbor or some sketchy message board. We're talking about our sponsor, Fume. And they look at the problem in a different way. Not everything in a bad habit is wrong. So instead of a drastic, uncomfortable change, why not just remove the bad from your habit? Fume is an innovative, award-nominated device that does just that. Instead of electronics, Fume is completely natural. Instead of vapor, Fume uses flavored air. And instead of harmful chemicals, Fume uses all natural, delicious flavors. You get it. Instead of bad, Fume is good. It's a habit you're free to enjoy and makes replacing your bad habit easy. Your Fume comes with an adjustable airflow dial and is designed with movable parts and magnets for fidgeting, giving your fingers a lot to do, which helps with de-stressing and managing anxiety while breaking your habit. The first time I used Fume, I was shocked at how flavorful and fresh it tasted. It's easy to hold and perfectly balanced. Quite honestly, extremely fun to fidget with. The real wood material and sleek design definitely classes it up, and I feel pretty darn cool holding it. Stopping is something we all put off because it's hard, but switching to Fume is easy, enjoyable, and even fun. Fume has served over 100,000 customers and has thousands of success stories, and there's no reason that can't be you. Join Fume in accelerating humanity's breakup from destructive habits by picking up the Journey Pack today. Head to tryfume.com and use code LEGALAF to save 10% off when you get the Journey Pack today. That's tryfum.com. Use code LEGALAF to save 10% off the Journey Pack today.
So for example, if a defendant is indicted for, charges in Fulton County and the offense occurs, say, in January, and the case is indicted, though, the following June, Fulton County has 2 terms of court running from June to September and one from September to December. If they file for the motion for speedy trial before the end of the current term, then the case must be tried before the second Monday in December. I know it sounds kind of confusing, but that's kind of how it is. And if if they don't try the case or commence the trial, then the defendant is automatically acquitted of all charges. So it on the merits, you can't try them again. And so this case will have to be tried by the end of the year, or at least commenced by the end of the year, now that Ken Chesebro made this demand. So one question is, okay, but what happens to all the other defendants, right? What happens to the 18 other defendants? So it's unclear, because normally a speedy trial for one means a speedy trial for all. And first, before I go into that, though, let's think about, why would Ken Chesebro want a speedy trial? Why would he want to go so fast and not take time to file all the motions that he'd want to file, attack the case, for various reasons, give these defenses, attack the sufficiency of the grand jury, attack, using the special purpose grand jury first, and then this other grand jury for an indictment second? I mean, who knows? There could be lots of things that he wants to argue, but instead he wants to go quickly. And why would he want that? I think it's a few reasons. I think it could be maybe he wants to clear his name. He's a lawyer who wants to just practice law and didn't want to get caught up in the criminal side of all this. Maybe he's calling Fani Willis's bluff, hoping she won't be ready. Who knows why he's doing it, but he's done it. But so what does it mean for all the other defendants, right? For the other 18 defendants? Apparently, that's in the judge's discretion, right? Judge McAfee, the very new judge who doesn't have a lot of experience. Fani Willis, if you recall, said she wants to try all of the cases together, and she wanted to do it in March of next year, of 2024. But I think that this judge will likely sever at least Ken Chesebro or anyone else wanting a speedy trial, because logistically, trying 19 people in one courtroom is quite tricky as it is. So perhaps for judicial economy reasons, he'll say, and the fact that certain people want a speedy trial, he could sever for that reason. Another sort of wrinkle in all of this is 3 defendants so far have filed for removal to federal court. So we've talked about this before on Legal AF and on various hot takes of what this removal is. If a defendant is a federal officer or working at the direction of a federal officer, and you have to have all 3, and he was doing the act that he's being charged with now, either civilly or criminally, but here it's criminal, under the color of federal law, meaning he was performing his job. That's what that means, while he was doing it. And number 3, he has some kind of viable federal defense, and you have to have all 3. And the most simplistic way to understand what federal removal is in a criminal context would be, like, say you have a federal law enforcement agent executing a search warrant, and in the course of executing the search warrant, he gets into a gun battle and ends up shooting and killing someone. He's a federal officer. He was executing his duties, right? He was in the course of executing a search warrant, and now he's being charged criminally, and he's going to have a federal defense here saying, I was acting in self-defense and I was doing my job, and et cetera. That would be removed to federal court. That's how you think about removal. But in the course of this January 6th trying to steal an election case, it's much more complicated. So Ken Chesebro can argue he was acting at the direction of a federal official. Now, he wasn't a federal official at the time because he wasn't working for the federal government. But I would argue that he was working for candidate Trump, not President Trump at the time. That candidate Trump was trying to steal the election to remain president, that it was not part of President Trump's duties or anyone else's presidential duties or federal official duties, that this was part of a campaign, and that Ken Chesebro was working as part of the campaign. And so I would argue that he doesn't even qualify as, even if he were to make this motion, as a federal official, even though he did not actually move for removal yet there. But the other individuals are moving for it, right? Trump, Meadows, and John Eastman. I'm sorry, Trump hasn't moved for it yet. I totally misspoke. Everyone assumes he's going to move for removal. Actually, the head of the Georgia Republican Party, David Schaefer, has moved for removal. So you have 3 cases pending in federal court waiting for the judge to decide whether or not there will be removal. And so you've got that going on. And now you've got Ken Chesebro trying to force a speedy trial. So it's unclear how this will all play out and what will happen to these cases. Will some go to federal court and some stay in state court? If some gets removed to federal court, does that mean all get removed to federal court? If let's say they all get removed to federal court, will the Georgia rules of procedure and speedy trial apply? Or will the federal rules of speedy trial apply, which then he would not be able to move for such a quick, speedy trial? It's just unclear because these are uncharted territories about how all of these things will play or interplay with one another. But that's what's happening right now with Ken Chesebro and the others. We will be watching the rest turn themselves in. They have until Friday of this week to turn themselves in. If they do not turn themselves in, Fani Willis claims that she gave more than enough time, 2 weeks, to turn yourself in. And if you don't, an arrest warrant will be issued, which means law enforcement can arrest you if you get stopped anywhere and bring you to court. So that's what's happening. And join us every Wednesday and Saturday for Legal AF at 8 o'clock Eastern. I'm Karen Friedman, Agnifilo. Thanks so much for listening.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.